to check in with a much more experienced, actually incredibly experienced defense attorney, former head prosecutor, Bob Bianchi. Bob, great to see you. Thank you so much for joining us on the program. And you heard the question. I feel like, you know, again, it's more art than science. You got to kind of go with, you keep your eye on the juror. You can kind of tell when you're losing them. It's probably a good idea to take lunch at this point. But are they going on too long with this cross-examination?
Michael, I think you hit the nail right on the head. It's not an exact science. It's something that you have to really gauge so many different nuanced things. And if you start to do it in a formulaic way, it will never work for you as a cross-examiner. The most important thing is, are you scoring the points you need to score? And I understand that you don't want to belabor and wear the jury out. I'm going back in my mind's eye to a trial where I crossed the defendant for 3 full days on the stand, and I was concerned that the jury would blank out, but I was continually watching them, and they were engaged, they were leaning forward, they were animated, so I knew I could keep on going. But there are times, I have to tell you as a lawyer, where you've scored enough points, and sometimes you find it hard to get out of the cross-examination because the witness keeps giving you so much good stuff, and you got to say, Bob, you got to get out and let it go. So it is an art form. It comes with experience, but so long as the jurors, 2 things here with this witness, are not blanking out, and importantly, do not feel that this witness, whose father was murdered brutally, is being beaten up, which will make them feel uncomfortable with the attorney, then you're okay to keep going if you're making points.
And I do think the demeanor of the defense has been very appropriate to not make it seem like she is beating up on him. But I must ask you this, because I think the state has the same potential issue. Bob, have they gone too far with the motive, the money, because they keep bringing up evidence of the money, but that's the motive. It's not an element of the crime. Can they go too far?
You're right, too, Judge. Motive is not an element of an offense, but as a homicide prosecutor, is one of the most persuasive things that you like to have if it's a good motive and if you don't beat that motive up too much. What strikes me about this case, Judge, is I've had at least 2, probably more in my career, where the money motive and the financial motive and the infidelity was the Geiger counter where everyone was going, and they were disregarding evidence that suggested other individuals may also have a motive to kill. And in fact, at the end of the day, it wasn't the infidelity, and it wasn't the insurance policy, and it wasn't the motive or the money motive, but rather some other thing. And by the way, one of the greatest detectives I ever had, a captain, my tactical operations captain, always used to say to me, when you're talking about money, motive, infidelity, and people who are lying, that doesn't necessarily mean they committed murder. Be careful.